I see way too many multi-million dollar deals just evaporate because someone didn't have the rights to the trademark.
Imagine selling on Amazon for 5 years just to get a legal notice from a company telling you that you owe them a significant amount of money because this entire time you've been infringing on their patent and they just decided to tell you now. Or you go and try to sell your Amazon business to an investor and they come back and say, actually, we can't buy your business because your trademark infringes or potentially infringes on a similar mark in your industry. By the way, this actually happens. Obviously, patents and trademarks are extremely important, but can seem complicated and scary, which is why we need an expert. And that's exactly what we're getting, because today, in this video, IP expert and the author of the book on obtaining patents, Rich Goldstein, who has over 2,000 patents filed over the past 29 years, is going to break down trademarks and patents in plain English. You are going to learn what IP is, how to use it to protect your business, how not to infringe on your competitor's IP and ultimately get sued, and also how to use IP as an actual monetary investment to increase the valuation of your business if and when you go to sell. This is an IP masterclass that most people are paying hundreds of dollars for in the form of masterminds, conferences, and one-on-one consultations that you're about to get for free. All you need to do, sit back, relax, and enjoy this video. All right, guys, I'm extremely excited about this video because today we have on legal expert Rich Goldstein, in my opinion, the most notable expert in the Amazon space regarding patents, trademarks, and all things IP. He also hosts some pretty rad parties in Vegas, which I've had the pleasure of being able to attend. So yeah, we can go ahead and dive right in. So first, IP. What is IP? Why is it important, especially for Amazon sellers?
Okay. Yeah, absolutely. Well, IP stands for intellectual property, and intellectual property is property of the mind. It's sometimes called intangible property. It's the way that you protect ideas, and it's got a bunch of sub areas that we commonly know of, like patents, trademarks, and copyrights. There are other areas in IP as well that are less known, which is like trade secrets. But in general, IP is the way in which you own intangible items, in which you own ideas, and just a crazy statistic is that like back in the 70s, if you looked at the most valuable companies in the world in the Fortune 500, it was like 6-1 that they had tangible assets to intangible. So all that wealth was made up by tangible. It's like you had companies like Procter and Gamble and Coca-Cola that owned trucks and ships and warehouses and real estate, and all of that tangible asset made up their valuation. These days, it's the complete opposite. The biggest companies in the world, companies like Alphabet and Apple, Microsoft, they own mostly intangible. It's the other way around. It's like 6-1. It's like tens of trillions of dollars in valuation is in their IP, and only a small amount is in tangible assets like real estate and things like that. So it's become so important. And so, if you want to follow the lead of the biggest companies in the world, they're heavily invested in intangible assets, which are mainly having to do with their branding and with their IP.
That is a super interesting statistic. And immediately what comes to my mind. So number one, we already kind of see a trend line, right?
Yeah.
From moving from this kind of physical to this, I don't know if you call it metaphysical, but right, kind of this IP or the importance of it.
Yeah.
And I know you just mentioned that you were at this kind of NFT event and you're kind of involved as well in the crypto space and the NFT space. So as the kind of metaverse continues to develop and virtual reality, augmented reality, I guess, would you see that this kind of trend continues? Because that's my first thought would be yes, like this would definitely then continue as things get more digital and consumers get used to kind of even purchasing digital products on top of, all the other things.
Well, as things become less physical, and then it becomes even more crucial to carve out your space using IP.
Super interesting. Okay. Yeah. So that's already really cool. So, okay. And then you mentioned there's kind of three main parts, aside from like trade secrets, which I know a little bit about, but maybe not as applicable to Amazon sellers. But within that, right, like there's copyright, trademarks, and patents.
Yes.
And then especially you kind of specialize in the trademark and patent space, especially
Yes.
that. So within
Yes.
that, so trademarks for Amazon sellers. Obviously, a lot of sellers
branding.
know. Yeah.
Yeah.
I was going to say a lot of sellers know that it's important for brand registry. So aside from kind of brand registry and maybe some, I don't know, protections that come with that, with your, I don't know, if your logo, your brand name or things like that, what exactly is a trademark? And then of course with that, why is it important to sellers? And we can kind of dive into that a bit.
Right. Well, trademarks protect the things that consumers use to identify your product and distinguish it from other products. So when they walk into a store and pick up a can of soda, they're like, oh, that's Coca-Cola. And they might not take the time to read that it actually says Coca-Cola, but they recognize the writing style, they recognize the color scheme. You know, all of those things are trademarks of Coca-Cola. Even the shape of the Coca-Cola bottle, like those old-fashioned Coke bottles, that's a trademark too. So it's trademarks are the things that consumers recognize that if a competitor were to use that thing, use that name, use that logo, use something similar to it, it might confuse people into thinking they're doing business with you. And that's why you want to protect it, is to prevent your customers from being confused. Your customers that have goodwill, they like your brand. You don't want them to mistakenly buy your competitor's brand. That's what trademarks are for. On Amazon, the primary trademark you want to get is what's called a word mark. And the word mark is to protect the name. And you want to prevent other people from using a confusingly similar name. You get a word mark registered. You can get brand registry. Under the right circumstances, you can even get brand registry ahead of time once you've filed a trademark application. So trademarks are important for that reason. And then again, so the first line of attack is always the word mark, protecting the name. Second to that could be the logo mark or a design mark, where it's protecting kind of the way in which you present that name, the color scheme, the style, and that's useful to get as well, to get a trademark on your logo mark, because sometimes people will copy your product branding, but not copy the same name. Classic example for me is, I remember, and I'll date myself, I don't care, I'm old, but I remember like back in the 80s going to New York City on Canal Street, where they had all the tables lined out with all the knockoff goods. And at the time, Sony Walkman was a big thing. And there was a product, and if you can picture the Sony logo, it's like SONY. And there was a set of headphones that were Kobe, COBY. And it looks just like Sony. And so, like, if you looked at it quick, you would think Sony just because of the way the logo was presented. And, of course, like back then, you can get away with selling things like that at a flea market. You could never sell it in a major store because Sony would be all over them. But that's an example of when the logo mark actually helps, is when they're not actually using a name that's confusingly similar, but the way they're presenting it, at a glance, people might think that's your product. So you start with the word mark, that's primary attack, and then logo mark. And then like more advanced companies like Nike trademark the swoosh, or you might trademark a slogan like the real thing for Coca-Cola. So any of the things that consumers identify is what you want to trademark, but you start with a logo mark, with the word mark. The word mark is always primary.
Gotcha, absolutely. And I know the viewers should kind of know this because we talk about this extensively on the channel, of how every month it's more and more advantageous to be brand registered on Amazon. It used to be, you don't really need to get brand registered, at least not right away. It's increasing to kind of all the access that you unlock from being brand registered. And in order to get brand registry, you need to be trademarked. I know one big question, it's one that I have that I haven't found a clear answer on. And that's why I love having an expert like you. You mentioned this, there's now an option with Amazon brand registry so let's say you register for a word mark, which again is kind of like protecting your specific brand name, that word, and then, or a phrase, I suppose. So you get that kind of like protected, get your trademark, but traditionally you would have to get the trademark kind of fully like filed and approved. Then you could apply for brand registry. But you might have mentioned, if I heard this correctly, that you can actually get brand registered before the trademark is approved. Is that correct?
Yeah, that is correct. As of the last time I looked, and who knows with Amazon, they're always changing things.
Yeah.
But yeah, if you filed your trademark application, you go into your seller account and apply for brand registry, and they will, as far as I've seen, they will typically give it to you. And there's a little bit of a process there where they send a notice to your attorney of record. Like, so in the U.S. Patent Office records, whoever filed it, they'll send an email to that person and say, here's a code. If it was your client who legitimately applied for brand registry, give them that code, and then they put it back into their seller account, and then the cycle is complete. So that's typically the process for how it goes. Just one little caveat. I've seen something recently where people have been denied brand registry because of the attorney that they used. Like, there's a notice that says essentially, like, your application is associated with an attorney who's previously been sanctioned or the mark invalidated, and something about fraud. I mean, I could find the exact wording. It was forwarded to me by a friend, actually, who encountered this. And so, I mean, there's that little caveat too, that if it's a shady attorney, you might not get it.
Oh, wow. It's this is the first time I've heard of this, but I hear about all kinds of things in the Amazon space. Like, you know, someone will ask me a question about whatever it might be, and I'm like, I haven't heard of that. Then I look into it, I'm like, oh yeah, this has happened to a few. That's interesting though. So you wouldn't be one of those lawyers, one of those shady lawyers that gets.
I mean, I'm kind of shady, but I haven't been caught yet. No, I'm just kidding.
That's a great response. Okay, very interesting. So basically, is it kind of once the trademark is kind of officially filed, then that code can get sent to the attorney to be kind of approved within? So
yeah, once it's officially filed, then you go into your seller account and you ask for brand registry, and then brand registry will send an email to your attorney and ask your attorney to forward you that email with the code, and then you put it back in your seller account, and that's how they verify that the person asking for brand registry is the same as the person who applied for the trademark. Because when you apply for a trademark, it could be under different names. It could be under the name of the company that you're using. It could be, there's different ways it might be applied for. So I guess they figured out that it's really hard to know for sure if it's the right person, except going directly through whoever filed it.
Gotcha. No, that totally makes sense. And the filing process is fairly short. Like, it was almost immediate. It's like the longest part of the trademark process. And I don't know, I'm asking this, but is it in the kind of approval process of, like, I don't know, paperwork getting sent somewhere and then the U.S. government kind of.
That is the longest part of the approval process. And it's taking about close to a year and a half these days on average.
Really?
Yeah. I mean, like, it's about 10 months to a year before you hear from them. And then there's a few other steps that might be a rejection or some issues to deal with. So year to a year and a half these days, where it was more like 6 months to a year only, a few short years ago. But there's so many applications being filed is the reason they're just backed up.
Wow. I did not realize, because I think for us, with our primary kind of like our last Amazon brand, which has been the one we've had for a few years now, it was about 8 months from, and I forget.
That's what it was.
Yeah. So you mentioned like 6 months to a year. I'm like, yeah, it was like right around 8 months. And I forget, there was the whole, like we submit it, and then if there's any like rejections or like issues, then we have to kind of like, I didn't know the whole process, but it went through. And another kind of question I have for you, not necessarily giving anyone advice, telling people to do this, but a strategy that I heard of, because there's so many kind of newer sellers, especially, that are creating their kind of like their brand name, which of course I believe you should put effort into. This should be, don't just sell a product on Amazon. That's a whole other discussion, but create a legitimate brand that's going to be around for decades, something strong. When it comes to a brand name, I see so many new sellers getting tripped up by this. And a tip that I heard, this is from another attorney, is like, hey, consider
making a brand name that's a fictitious brand name or a name that's basically like made up. Because I know there's, I think, some different categories of names that you could choose. Like, I'm trying to think of an example, like I don't know, Fiverr, if that's one, it has the word five in it, but I guess Kodak or Exxon, or those are some examples of like brand names with the fictitious. Not saying like go do this, but that I've heard, and I'm wondering if those type of brand names tend to have higher success rates of like less objections, because assuming they don't sound and look just like other existing brand names that are just like slightly different, but a completely made up brand name has less likelihood of getting, I don't know, rejected. Is that?
Yes, no, absolutely. So let me just explain how that works. So for something to be protectable, it needs to be distinctive. Something that's not distinctive is when it's generic, like the name you actually ask for, like aspirin, or it's something that's descriptive. It describes the product, like red licorice. You can't trademark that because you can't stop other people from calling their product red licorice if it's directly describing it. So what you look for is something that is more distinctive than that, which should be suggestive, arbitrary, or coined. Okay? So suggestive means, okay, it's not descriptive, but it's kind of creating an image in the mind of the person. So something like Northern Forest air freshener. Like, it doesn't exactly say what it is. It's not like pine scent, Northern Forest. That could be, that suggests to someone, oh, like fresh and, you know, like outdoorsy. That could be trademarkable. The next step up is arbitrary, like Apple computers. Apple is an actual word, but it is not, it wasn't typically associated with computers before. So that's called an arbitrary mark, and that's strong. But even stronger is coined, like using Exxon or Xerox, made up words. A made up word, then it's like, why would any competitor need to use that name unless they were trying to ride your coattails? So those are the strongest marks to use. So yeah, I mean, and the Chinese do this a lot. They make up kind of like ridiculous names, like, you know, boy fly for like, I don't know, a hand lotion or something, you know? And that's another important thing too, is that like trademarks are specific to a certain type of product or service. You don't protect the name in a vacuum, like just like that name for all purposes. You have it in association with a product, like skincare lotions, or you know, writing, you know, pens, or you know, or computer memory chips, or whatever that is.
Interesting, because I did hear this before. I believe that there was like, I think it was like a court case. There was like Pepsi Trucking Company and then Pepsi Cola. So two completely different industries. And of course, I think Pepsi Cola like sued. They're like, hey, like you can't use our name. And I don't know all the details, but something like that. And I actually don't remember the result. I think that the Pepsi Trucking Company, from what I remember, was able to like to maintain their trademark, or their brand name. But yeah, that's interesting to where is, so in general,
I coexist in different fields. You know, like General Electric, General Motors, you know, it's just, it's possible. But the more famous the mark is, the less likely that's the case. It's kind of like if you wanted to open a McShoe store, McDonald's would be all over you, because they're like, people will, our mark is so famous that when people see McShoes, they think it's an offshoot of our brand. So as, you know, as marks get more and more famous, time and space warps a little bit, and like the rules change, and like they get away with a lot more. But in general, you could have the same name in a very different field. Like, you know, I've got, you know, this like founder's card here, and you could have like, you know, a mastermind named Founders or something like that. It's very possible to use the same name in different realms. It all comes back to the same thing with trademarks: likelihood of confusion. Would people tend to be confused between your competitor and you, like when they're using a similar name or similar logo? Then that's trademark infringement. And if someone new is coming into the game and they want to register a mark, if it's likely to be confusing with an existing mark, they won't get it. So it's all about like likelihood of confusion, which comes down to kind of common sense. Comes down to, well, what would people be confused? And ultimately, in court cases, they ask a jury, which is just a bunch of regular people, like, you find this confusing?
Oh, interesting. That's such a like a very obvious, a very clean way of looking at it.
Yeah.
I don't know, and that's what we mentioned at the offset of like that's. I also have the stigma of like it's. I mean, of course, there's complexities in it and all of that. Of course, that's why we have high-paid legal experts like you to do some of the deeper digging when it's required. But it makes a lot of sense. And I'll say this as well. There was I have to try not to say too much information, but there was a client that I had and they were just kind of running through the Amazon process. Oh, we got our product, developed. They did a great job. They were making this backpack. Really great job with product development. They went to go launch. They named their brand Gapped Travel. So Gap company sent them I guess cease and desist and said, yes, don't use because you're selling apparel and you have Gapped Travel in it, and we think that that's similar. And I don't know if that's just somewhat intimidation or if it's also like, I mean, that is somewhat similar in the same maybe ish category. But basically, I see so many sellers just rushing in, and there are these important points. It's like no, like make sure you do your proper research, and proper naming and all of that. And sometimes of course, consult a legal professional.
Yeah, well, I mean, that's the thing is like, especially if you're going to launch a brand, you're going to spend a lot of money in promoting that brand. And if you have to find out after a pretty big order and some significant marketing and promotion that you need to change the name, that's going to hurt. It really pays to do the research at an early stage. And I never understand why people skimp on this stuff. It's not very expensive. Trademarks are relatively inexpensive. For a couple to a few $1,000s, you can get it researched and filed. And I see way too many multi-million-dollar deals just evaporate because someone didn't have the rights to the trademark. And even worse, that maybe someone else does have better rights than they do.
Oh, wow.
So for not spending a few $1,000s, people often lose millions. So,
wow.
Yeah.
Okay. No, that's that's crazy. So, that there are certain brands that have been selling for some time, let's say on Amazon, D2C, whatever, making millions, they're going to go exit, and then they go to sell to some venture capital or whatever. And it's like, they'll do the research, be like, no, like there's some discrepancy here. There's someone else with a similar mark or whatever. That's terrifying. What would you say?
You get the attorneys doing their due diligence for the deal, and attorneys are usually pretty risk averse, and they're like, we don't like it, and blah, blah, blah. And so, I mean, ask any aggregator if they've had deals like that. And every one of them will say yes. We had a deal which looked good. We did our due diligence. There was a problem with the name that they didn't have the trademark, and that the deal fell apart.
Wow, that's a great reminder. It makes me a bit nervous, but I always get a little bit paranoid with things like that. I might have to have a talk with you after this
Okay.
call. No, but that's great. And what would be, because obviously at certain times it's probably necessary to actually have a legal professional go in and
Right.
kind of do some heavier digging. But kind of on the offset, is there any tools, any sites that sellers could use, at least to like, how could I just generally tell if this idea for a brand name that I have like remotely infringes on anything that's out there?
Okay, well, there's the USPTO.gov website where you can do trademark searching. There's a few caveats though. If you're gonna search it yourself, you might not know exactly what the significance is of what you found. So just to give you an example here, it's like, so you let's say have a name for a product. I'm looking around. I don't have sometimes I just don't have an imagination about this. I got some cough drops here, Halls, right? Okay. So imagine that it wasn't the famous brand that it is, but you want to sell some type of medication called Halls, right? And you do research and you find a company that's already selling, let's say you want to do Halls Relief. You find a company that's selling Halls something or other in this realm. That would probably be a good reason not to proceed. But if you found that there was Halls Relief and then there was something called Halls Daily, that might be reason why there's room for yours as well. because it's like trademarks are all about preserving the consumer expectations about like where the source of a product is. And if there's one other company that has the trademark, that company say, hey, if they see your product, they're going to think of us. But if there's two companies, that first company can't really say, well, they think of us, or maybe they think of the other guy. So it's not really distinctive to one particular company. Maybe it comes more down to what the second word is or such. So if you do your own searching, you might mistakenly at times say, well, this is bad news, when actually it's good news that you found a bunch of things. So that's just one little example. Other thing too is you have to look for sound-alikes. So like when we do trademark searching, we're looking for other words that sound alike, that might be confusing. It's not an exact match, but it could be potentially confusing. So yeah, just a little bit of caveat there about what to make of the research results. But you can search at uspto.gov and get a feel for what's out there, and get a feel for how crowded it is, and like that.
Gotcha. Yeah, there's a really interesting insight too about the like two potential. Obviously, it's not like if this then therefore this, because like of course not. Like
Right.
there's it's nuanced and all that, but potentially, because of course exactly what you said. Like if I saw two marks that already exist, I'm like, okay, now there's even less opportunity for me. There's definitely not. Where actually it could mean the opposite. That
It could mean
actually,
that there's more opportunity. Yeah.
yeah.
Yeah,
Huh.
depending.
Very
And then
interesting.
it also depends on what type of product or service they're offering, whether there's an argument to distinguish it. And you use the right word, the nuance. Trademarks are relatively simple, but highly nuanced. And trademark attorneys, IP attorneys that have a lot of experience, have filed hundreds or thousands of marks. They know like where those cracks are, and where kind of steering the ship a few degrees to the left might actually make the difference between getting it and not.
Gotcha. Super interesting. Okay, that was I mean, basically you just listened to an entire masterclass on trademarks. That was some
Yes.
really, really good info for that I think like I said, I just think is not being covered, or at least definitely not being covered like this. So that's
Yeah.
been fantastic.
Oh, and by the way, if I could just interrupt you for a
yeah,
second,
please.
I think you were going to wrap up trademarks. I found that notice there from Amazon, and I'm just going to read it quick. It'll take about 30 seconds.
Yeah, please.
Because I think this is news to a lot of people. So this the screenshot of the notice. It says, "Why is this happening? As part of the enrollment process, the detailed investigation was conducted based on the information available in internal systems and information and documents provided by you. After carefully reviewing the information and documents, we've concluded that the brand user is currently ineligible for brand registry, since the trademark registration was filed by an attorney who has previously been associated with a trademark that was sanctioned or made invalid by the United States Patent and Trademark Office for violating USPTO's terms and conditions." What's the next step? In order to move forward, you'll need to file a new trademark with an attorney who has not been associated with any abusive, risky conduct in the past. You may reapply for brand registry with the new trademark by visiting brandregistry.amazon.com/brand/enrollment. So
Interesting.
that was kind of shocking to me. And, but I think it's kind of called for. I mean, there are a whole bunch of attorneys doing some shady stuff, especially, there was a lot of antics coming out of China with regard to trademarks and hijacking actual trademark applications. And I guess they flagged some attorneys that that kind of were just filing frivolous marks, or I don't know exactly what they did to warrant this, but I never would have imagined before that the attorney you used could have that big a difference.
Yeah. I was saying that, like I said, this is the first time I'm hearing about it. I'm not as, up to date in the kind of the legal side, obviously, but
Yeah.
that's very, very interesting. So yeah, so when you do, select an attorney, do your due diligence and watch out.
Yeah.
Okay, that's very, very interesting. I'm already I'm taking notes. That's why I'm looking down. So that's been already amazing on trademarks. I know we've already gone through a lot of time, but I would love to kind of dive into patents a little bit. I think that's especially kind of your bread and butter.
Yeah.
So what are patents? maybe the different types. Why are they important to sellers? When should we get it? All that good stuff.
Okay.
Or as much as we can get to.
Yeah. Let's jump into it. So patents give you the right to stop other people from making, using, or selling a product. It doesn't give you the right to make a product. There might be other reasons why you're not allowed to. It could be unsafe. It could violate consumer protection laws. And it doesn't also say that you might not be infringing someone else's patent. But for the thing that you're patenting, for the combination of elements, A, B, C, and D, or whatever that is, it's a microphone having a base and a receptor with an element inside, whatever, that combination, you're able to stop other people from making the same thing. And so essentially that's what a patent is. It's what they call a negative right. Not the right to do something, but the right to stop other people from doing it. And that right you could leverage in many different ways. One of the ways is by licensing, is by you find a company that wants to make the product on a big scale and they can't do it because of your patent. Then what you do is you enter into a licensing agreement where they agree to pay a royalty in exchange for being able to do the thing that would otherwise be prohibited under your patent. So that's what a patent is. There's two main types of patents. There's a utility patent and a design patent. So now utility patent is what you typically think of when you think of an invention. You think of someone in their garage trying to improve something, making it functionally different. So something with different structure for a functional purpose. That's what a utility patent is for. And a design patent, on the other hand, is just about the way that the product looks. There might be nothing different about this microphone, but this particular shape to it, the taper of the handle, maybe the pattern on the top here, that could be the subject of a design patent. Now, traditionally, people look at utility patents as more valuable than design patents because utility patent protects more of the concept of the product, design patent just the way it looks. And people would traditionally have said, well, yeah, design patent's not really worth it because you change the way it looks, you're not infringing. Except on Amazon, how do people copy your products? They just knock it off. They don't get creative. They don't get inspired by your product and say, hey, let's design a product like this, and we add our own design flair to it, etc. They just say, hey, what factory in China can make us 10,000 of these? And so if you have a design patent, then you'll be able to shut down the competitor because it will look the same. But even more than that is on Amazon, like in the old days, like before Amazon, if you wanted to go after someone for infringement, you had to bring a court case, which might cost you $500,000, $2 million, whatever. But these days, if someone is infringing your IP, you can just do an IP complaint through Amazon. You don't need a lawyer. You just, within your seller account, you can create an IP complaint, and Amazon will review it and possibly shut them down. But now here's the interesting thing. Those less valuable design patents now are easier to enforce on Amazon because utility patents are judged through words, through a description. Does it have those elements A, B, C, and D? There's like a long description at the end of a utility patent, both claims. And so it's like you're having like a $12 an hour employee at Amazon looking at your claims. They're not going to know what to do with it. They might kick it over to another procedure. But when it comes to a design patent, it's a matter of, does it have a substantially similar appearance? So they'll look at the pictures of your design patent. They'll look at the product and say, okay, shut them down. So it's actually really easy to shut down a competitor who's knocked off your product if you have a design patent. So design patents have become a bit of a no-brainer on Amazon.
Interesting. I didn't realize how powerful they were. That totally makes sense then. I mean, I know that certain sellers have abused the IP complaint, and I have a buddy of mine who had, it was a, I don't know if what did they do exactly? It was some kind of weird manipulation. I think it had to deal with copyright, but they knocked off his product, then claimed that his product was knocking off theirs, and then got his listing shut down. And he's like, this whole mess. But he didn't have proper protection. So that's okay. So when it comes to Amazon, especially, those design patents can be, really powerful. And I love the way you described it, which I didn't even think about. It's preventative. It's preventing others from copying the design of your product. So so I guess number one, there's kind of two sides of this, right? There's like the seller, like, I want to protect our products and our brand. Then there's the seller, I don't want to infringe on someone else's protection. So what would be like maybe some basic ways that someone would be able, maybe not fully identify, but to some extent identify that a product doesn't infringe on an existing patent? Because that would be horrible, I guess, if like you create a product, you get an IP infringement. Obviously, there's sellers who just sell whatever, and they fully deserve it. But there's certain sellers that I know who have, put in a lot of effort. It was one of those elements, right? IP that's so important that it's not in these checklists, especially a lot of these YouTube gurus, right, that have never sold on Amazon. It's not on their checklist. Those free downloads that you get, right? The IP aspect is never there, so it's never in the mind to be on the checklist. So they completely ignore it, not intentionally, and get into this trouble. So like how could a seller like take measures to not infringe on existing kind of IP, especially like with patents?
Yeah, with patents, it's very difficult. It's very difficult. It's so first of all, like with a bigger brand, a brand that has the resources, they would have us do what's called a freedom to operate review, which is basically, am I infringing? Like if I wanted to make this product, am I infringing on any patents anywhere? And that could be really difficult to do because like, it may be that there's a design patent for the shape, right? It may be that something about the connector in here, like there might be a patent on that. There might be a patent on like the element inside here and the way that's arranged. So there could be multiple patents on a given product. And so it's like an inquiry that splinters in many different directions. And it gets very expensive, like minimum, like 4 figures, sometimes into, no, not 4 figures. I'm counting the wrong number of figures, 5 figures, like a minimum 10,000, like $10,000 would be a very simple freedom to operate. But you could spend $100,000 on an electronic product. Like if you were launching a new cell phone, you might spend $1 million on a freedom to operate opinion because there's so many different pieces of the technology that have to be reviewed and searched, and then possibly infringing patents then have to be reviewed by an attorney who might spend $5,000 or $10,000 each to review those patents in depth. So it is a very expensive proposition to really do it the right way. And consequently, it's just beyond the reach of most sellers to do a real freedom to operate review. A couple of things that can simplify it, though. One is like if there is a patent out there and it's got a patent number, it might pay to have that patent reviewed. And I'm going to tell you, like 99 out of 100 non-attorneys wouldn't know what to make of a patent. They'll look at it and say, well, oh yeah, well, mine doesn't have a battery compartment like theirs, so I think I'm clear. But that might not be what the patent actually is standing for. That might not be what it would take to infringe the patent. You might be infringing in some other aspect. But yeah, if I had one patent in front of me to review, that's way simpler than a freedom to operate. That's just called an infringement review. But some other rules of thumb there too. It's like if anything was patented, anything was part of an expired patent, and patents last 20 years from when they're filed. So if anything's part of an expired patent, you're free to make exactly the product in the expired patent. So when you know that something has been around for a long time, you're making a basic stapler as they've been for decades, then you're probably in the clear. If you're making a product that's pretty new and is actually pretty clever, then there's a higher risk that you could be infringing on the patent. But that's one of the shortcuts, is to find old patents When it comes to trademarks, again, the test is common sense, likelihood of confusion. It's kind of like if you think you're trying to trick people into thinking that they're the brand that's the number one seller, then you're headed towards a trademark problem. I mean, with copyright too, that we didn't talk about, it's like it's also kind of common sense. If you think you're ripping someone off, you probably are. You know,
100. This is a huge thing that newer sellers like. I hear, for example, I hear this. So like can I make like my own like Mickey Mouse X, Y, and Z?
right?
You know, it's like,
no,
what do you think? Do you
No,
think
like,
that
what
Disney's
planet
like,
are you
yes,
from?
please? Yeah, I just think a lot of people, and I, to an extent, like kind of understand where they're coming. But here's the thing: it doesn't matter. Understanding empathy, rules are rules, right? The law is the law. So like, you infringe on it. I mean, yeah, there's chances you could get away for a certain amount of time, but and this is actually something else I wanted to. There's a couple. Anyway, really, really good info on patents as well. Like I said, you got my brain kind of spinning a bit, and something I heard from another seller, and you could let me know if this is something that happens somewhat often, or at least has happened before, is there's a certain seller that was selling this product that was infringing on a patent, and the patent owner let them sell for like 3 years, and then filed a claim that they had to get a certain percentage of sales over like the past 3 years, something like that. To where like they were selling like, oh yeah, either we're getting away with it or we're just clueless, let's say, and we didn't do our proper research, selling this product, making money, all that, but then gets hit with this patent infringement, and I guess has to cough up I think a pretty hefty amount to the patent holder.
Yeah. Well, yeah, and they could do that. I think the limit is 6 years for damages. So yeah, someone who's not enforcing can come back around and enforce later on. I mean, if we just step in their shoes for a minute, maybe that's how long it took for it to add up to something that was worthwhile.
Gotcha. Yeah, it's a bit of a scary thought, but it's something that's why, like I said at the beginning, it's good to like confront, like have the right picture before you go in, instead of like, here's something I don't really want to deal with right now. Oh, it sounds expensive. It sounds complicated and scary. Let me put it off. It's like, don't put it off. Like it's something you need to kind of confront, and it's not something that should be scary, right? Especially with the right help and guidance and all that, not just, doing it on your own. Oh, I feel like this doesn't infringe, I'm going to sell it.
Right.
And
here's the thing too. Here's the total flip side to it. You see a product with a patent number, that should not necessarily stop you from doing it. You should look into it. If it's a product that you think could be good, I'll have to tell you that 9 out of 10 times that they put a patent number on there, and they don't have a patent on the concept. They have a patent on some of the details, like, because the concept itself wasn't new. See, here's the thing. Like, you can get a patent that covers a whole new concept if you actually came up with a whole new concept. Most of the time, when you're going to get a patent, like, you do research, there are other people that have actually done that concept, maybe back in the 50s and the 40s and long time ago. But okay, there are some details about yours that are distinct. You can still get a patent, but now your patent is going to be on the details, not on the big concept. And so,
yeah, because the big concept was already done.
What's that?
Because that big concept was already done.
The
So
big
that's
concept was
interesting. I
already
didn't think
done.
about, because so the patent now kind of clicks. You mentioned this, right? Like a patent, so it's 20 years. Like, all right, can't infringe on this for 20 years, and then after that, it's like open. But it's open, but it's that patent still exists. The patent doesn't disappear for someone to recreate, obviously, because then there'd be this endless loop.
Exactly. It's still what they call
Okay.
prior art. It's still useful for judging whether new inventions are different from what has been done before. So the patent expires means anyone is free to use it. But you can't go patent the light bulb over again, even though the patent expired more than 100 years ago. But as time goes on, people say, I didn't invent the light bulb. I didn't invent the idea of like a thin piece of wire in a vacuum that will then glow. But I came up with a better way of suspending the filament so that it doesn't break under shock when it's hot. That could be a patent, right? And then you have a patent on whatever that technique is, that structure is that does that. Now, is that going to be important to the marketplace? Are people going to look at it and say, oh man, we want the light bulbs with that, or are they just going to say, we want a light bulb? If they can say, well, we want a light bulb, or if you as a competitor can say, I just want to copy a light bulb, I don't want to copy your suspension structure, then you can do that. And that's why it pays, even if you see a patent number, to look it up and look into it and find out what does that patent actually stand for. You might still be able to make that product.
Interesting. That's a great point. So certain sellers are doing this defensively. They're kind of intentionally, getting patents for themselves on this, this very specific kind of like element. Mm-hmm. And then not necessarily intentionally try to portray it like it's more than what it is, but just to have it, just say, hey, we've got a patent on this product. Just so
having it
fewer
keep
people.
80% of people away. Just having it. Like they'll be like, they don't know what they're looking at. Let me look at something else. So that's one.
Very cool defensive strategy. I love that.
But
That's
yeah,
so cool,
it's not just a defensive strategy. It's a valuation strategy. And it's the reason that if you get IP, you will increase the multiple when you're selling your business. You'll get a huge ROI on anything that you put into IP, into trademarks or patents, because it stretched the multiple even a little bit. So it's like, here's kind of like a example. So you build up a business, you've got $2 million in EBITDA. Maybe someone was looking to pay you a 4-time multiple without any IP. If you've got the type of IP that prevents competitors from entering the space, instead of a 4, maybe you get a 7. So that's an extra $6 million on that $2 million in EBITDA, that extra 3-time multiple. But like, let's say it's kind of crappy IP, and you don't, it's not, can't really stop the competitors from doing it, but it's the type of thing. It's marked with patent numbers. You've got the R with a circle around it for the registered trademark for the brand. So, that principle of tending to keep 80% of the people away still exists. So then someone acquiring it, instead of giving you a 4 multiple, maybe they give you a 4.5, but it will always stretch it a little bit, at least like that. And what's that extra 0.5? That's an extra $1 million in valuation on maybe having spent, let's say, $30,000 on IP. So that's like a 33-time ROI. So there's these two big reasons for doing IP. One is like having to do with like defending your listings and keeping people from taking away your sales and affecting your profitability. But the other is exit valuation. And to me, exit valuation is always a no-brainer, because you'll always get an ROI on money you spend on IP, even if it's crappy IP.
No, that's a great way. So obviously the better kind of quality and some of the higher level, like aside from just like some basic trademarking, but getting into kind of some of the design utility patents, better done with a non-shady attorney and all of that.
Yeah. If you can find
your
one.
multiple further.
I don't know where to find a non-shady attorney.
I think you've said it a couple times now.
No, self-deprecating humor usually.
Yeah. No, and of course everyone knows, like, if anyone's on the channel, like they're fully legit, they're great, and you can look at Rich for your own. Yeah. Great stuff. But I was gonna say at the offset, you got the black background, you got the black mic, the shirt, and the leather chair. A little bit like an evil villain there.
I'll up it a level here.
There we go.
Okay, and yeah, okay.
Yeah, forget IP. Just get rich, and every competitor will flee immediately.
Right.
No, that's amazing. No, that's great.
You know what's really funny? Yeah. Like, I did a Zoom call with a client. This client is just on Shark Tank. They're awesome bunch of guys. But like the first time I did a call with them, I was in, I just like Puma zip up, and they said to me some later time, because we became good friends. We hung out a bunch. We went to the Magic Castle in LA together, and they said, like, when we saw that we had a lawyer in a tracksuit, we were like, that's all we've ever wanted.
That's amazing. That's amazing. No, I could totally, I totally get what they're saying. That's fantastic. And one last, it was a quick kind of a random point going back to what you mentioned.
Right.
So a lot of times when the product is more complex, there could be more, obviously there's more technicality there, more complexity, then more likelihood that there could be like a potential patent infringement.
Right.
I always tell brand new sellers, like, hey, you just want to like test the business model first. I'm helping this nonprofit like get their they have these headbands that are made from like cruelty free, like all this, human trafficking type of nonprofit, getting them onto Amazon. And I'm like, all right, take your like headband and we're going to test that first before we get into more of your complex products. for a lot of reasons. And what I always used to say, and this especially gets in electronics, is more complexity. There's more things that could go wrong when you get an inspection service to like check. You know, there's more things that could like kind of be missed. And then it also goes into IP, right? That obviously also at the same time where there's more complexity, there can be opportunity for people doing it the right way and kind of going through the process, putting the upfront capital that's needed for that entire, like the sourcing, the IP search and all of that. But for a lot of sellers, it's one thing I want to mention because there are, you know, of course that's most, you know, newer sellers. Maybe another reason to consider going after some of those more simple products to start, test the Amazon business model, and then kind of go and scale up a bit more. Because you might have, again, you have to do the right research, but might be less likelihood of infringing versus like a very, very technical product.
Yeah, and there's a couple things to be aware of in that approach. And like, I mean, certainly sellers, like other entrepreneurs, they have to preserve their resources. Like, and like if you're launching a product, you've got limited resources and you want to spend those resources on the things that are most effective for you, right? And so a patent might not always be top of the list. By the way, trademark should be. Always do your trademark at an early. If you're going to invest anything into a brand, do the trademark. It just it pays. Like it's a good practice to make sure you always do your trademarks. But here's the thing: when it comes to patents, there are time limitations. So in much of the world, if you launch the product without having applied for a patent, it's game over. It's too late. You can't circle back to it. In the US, there is still a 1-year grace period, so that if you were the first one to launch it and make it public, if you file your patent application within a year, you're okay. But beyond that, it's game over. And too many people don't know that. And, you know, granted, it's totally understandable as a seller, as an entrepreneur, you know, like, let me launch it. And if it does well, then I'll patent it later. I've had way too many people in my career come to me with a product that they're selling, they're doing well with, and they're like, I've just got to patent it now. I don't care what it costs. And I ask them the question that I don't want the answer to, which is, how long have you been selling it? And they'll say, well, 18 months. I'm like, I'd love to help you, especially since you say it doesn't matter what it costs, but I can't. There's nothing we can do. So that's something to keep in mind, is that you need to apply in the US. You need to apply for a patent within 1 year of making it public. There's another thing to be aware of that I've encountered quite a bit lately. And, you know, there are people that know of this 1 year rule and are like, okay, I'm going to just make sure we file it within a year of launch. Amazon, under their first of, like when you make an Amazon listing and it says on a lot of the listings, date first available. A lot of times the date they list there, first available, is the date you create the catalog entry, which is well before, you know, you have inventory at the warehouse, and then you actually make it live, which rightfully would be the date of public disclosure. But I've had rejections where the United States Patent Office examiner says, "Oh, look, Amazon says date first available on this date. That's more than a year, and so it's not patentable." So keep that in mind too. Like if you are going to use that full year, then make sure that you're keeping in mind that whatever date Amazon puts on that listing there, because that can be hard to overcome.
Oh, wow. Totally makes sense. That's a really good point. And I think the last question that I have kind of about patents as it relates to kind of like for a lot of sellers, I know this definitely depends, right? But when would someone know that they want to pursue, or maybe that they should be pursuing design and utility patents for their product? Would this be more kind of like, you know, we kind of say it like this, you know, Kickstarter style products, like not completely necessarily new inventions, but something a bit more, you know, someone kind of created this. I'm friends with a product designer. He comes with new designs like all the time.
Yeah.
So some of those more, I don't know what the right word is, novel or
well,
kind
more
of
distinctive looking. You know, like I think if you could swing it, any product that has a distinctive look to it, you should be getting a design patent for. Utility patents, and this is the thing, utility patents are more expensive too. You know, utility patents like 10,000 and up, 10,000 for something very simple. And by the way, if we're talking about a software platform, probably 20 to 25,000 to apply. Design patents more like 4,000. And So if it's a product that has a distinctive appearance, then you ought to do a design patent, especially if you're going to be investing, $20,000, $30,000 even into initial order. It probably pays to put a chunk towards that. And if you're building multiple brands, having a portfolio of patents is going to greatly increase what you get at exit.
Yeah, absolutely. It totally makes sense. Now I'm thinking about our own products. I'm like, okay, like I'm gonna do an audit. Do you ever do that with sellers where you kind of look through their product catalog and obviously there's certain products like, yeah, no, we're not patenting these. It's just kind of like, whatever add-ons, kind of upsells. But some of those more distinctive, unique products that are created that you could maybe go through and like, okay, this could be worth pursuing.
Yeah.
With a design patent, and we can move forward with that. Is that something you've done with sellers in the past?
Yes, no, definitely. And like, some of the stuff like, you eliminate right off the bat and say like, okay, you're just selling, plastic knives and spoons. Those are the same as every other one. That's not going to be like, don't even bother with that. You see something else and say like, this is a definite candidate. And a lot of other things are in the middle. It's like, hey, this could be good. We might need to research it. But yeah, absolutely. Absolutely. I mean, there are, like there's a lot of products that just don't pass the sniff test. And we could say that let's not even consider that.
No, totally. Especially with your experience. It's the same thing kind of with when you start selling on Amazon for a few years. You're able to kind of tell, okay, yeah, I get this product. Yep, this is going to perform well. This product, like, yeah, no. Like, you can kind of get and especially on top of that, with your years of experience and your extensive knowledge and legality, for you and your team to be able to look at some of those, I could totally see, like, this sniff test of literally just where someone else, like, I have no idea. And for you, it's like, it's obvious to me, absolutely not. Like, I'm not even going to do the, it's like every other product.
Yeah, exactly. And on the utility side, it's really a matter of like how groundbreaking it is. It's like if part of your narrative about your product is like, hey, no one has ever done X, Y, and Z before, maybe we should look at a utility patent. And that's kind of what it comes down to, is how innovative is the product. And by the way, just another little principle to throw in there, just to help kind of round out the knowledge of how patents work, is to be patentable, it not only has to be different from something where it's not exactly the same, it has to be different in a non-obvious way, which means like if you just add something that maybe no one has done it exactly in this context, but it's kind of within the range of what people who design products would think they could use, then it's not going to be patentable. It's like, when we made this biodegradable, that's not going to be patentable. It's like, we made this so it could be a single-use product. Well, yeah, I mean, the way you make something single use is by making it cheaply enough so that you could throw it out after using it and replace it. It's like changing the size of something typically would be obvious. Changing the material would often be obvious. Unless it's like something just unexpected. You take a material that's often used in semiconductors and you realize that it's useful as for polishing your shoes or something. If something unexpected could be patented. But a lot of times people will say like, well, we've made improvements on it. Ours last longer. It's more durable and it smells better. Like, you're not going to be able to patent those types of features. But if you say, oh, these eyeglasses, we've added this little notch in here that will keep it in the open position, that could be a utility patentable function.
Gotcha. Totally. Instead of like, adding on to what already exists, like really that different, it actually is different, like something that's unique, that's not
Right.
obvious. Totally makes sense. Very interesting. Very interesting. No, this has been, like I said, the title of this is the the IP Masterclass with Rich Goldstein, and it's definitely lived up to that. This has been super, super insightful. I know there's probably even more, obviously, gold nuggets you could share, and we could go on for hours. Of course.
Yeah, we could, but I think we covered quite a bit. I think we really got a lot done in this time.
Absolutely. No, I've appreciated you just spilled so much knowledge. I have like a whole notebook here of all the notes that I've taken, and I hope everyone that's watching this has found this valuable. Because, like I said before, Rich, I mean, where we kind of met, I forget when it was. It was I think a little while ago now, but speaks at some pretty high level conferences. Has his own podcast. So like him being here in his time, like this is. I just hope people realize how valuable this is, and I'm sure they've kind of seen that from what you've shared. So I really, really appreciate you coming on. And what is, because obviously you got more to share. What is the best way for people to kind of learn more about you, some of your insights, if they want to kind of utilize your services?
Okay, yeah, absolutely. Well, I mean, first of all, I'm a big proponent of learning about IP. The American Bar Association asked me to write a book to explain IP in plain English, and it's kind of like the book is written the way I've been describing things here. It's just like we're sitting across the table talking to each other. If you want to check that out, it's the ABA Consumer Guide to Obtaining a Patent, and you could get that on Amazon. It's $20. It's about a 4-hour read, and if you read it, you'll know more than 99% of other sellers about how patents work. I also do a podcast, Innovations and Breakthroughs, where I follow the path that people take from having a concept in their mind to something that's actually real out there in the real world. And I've had fantastic guests on the show. And then if you want to learn more about what we do, the website is goldsteinpatentlaw.com, and there are videos and articles and other resources there. But also, if you want to find out if it's a match to work with us, like if we could help you with something, schedule time with Larry Slavin. And he, like his job is really to go over with people where they're at and kind of like how we could help them and help sort them out in what they might need next. And you could just set up an appointment with Larry conveniently at speaktolarry.com. So speaktolarry.com and set up an appointment, talk to Larry, and see if we're a match to work together.
Yeah, absolutely. No, that's fantastic. And also, all of the links and everything that Rich just said will be including in the description section and kind of the comment section of this video to make it easy to find. But yeah, Rich, this has been amazing. Really.
Yeah, this is awesome. I really loved this conversation. Thank you so much for having me.
Absolutely. No, thank you.